With that, Mr. McKeska, would you please begin the announcements?
Joint McCaskill, attorney for the department.
Okay.
January
Oh.
Nevada's adoptions caseworker.
Kathleen Savage, attorney ad litem for the child, Your Honor.
Laura Martinez, adoption supervisor.
Go ahead, Gavin.
Gavin Fox.
And we are waiting on Casa to join us.
And then I'm off screen. Hi, Your Honor. My name's Uriah Bynum. I'm his case manager at Little Creek.
Thank you, sir.
You're welcome.
Today.
All right.
Amy Harding, Hill Country Casa, guardian ad litem for Gavin Fox.
Okay, Ms. Nevada, your report states at this time Gavin's 15, is in group home, or GRO, excuse me, in Harris County. Is that still the case?
That's correct. I actually believe, Your Honor, he's 16. So
Okay.
I apologize.
That's all right. And is that placement safe and appropriate, meeting his needs?
Yes.
Is it in his best interest to remain there at this time?
Yes.
All right. And
I apologize, Your Honor. I think I sent the wrong, I had made some changes and I sent the wrong one, but he is actually in an RTC, not in the GRO.
okay, is it in Harris County?
No, sir. He is actually out in Arkansas.
Okay.
I apologize completely. I sent the wrong revision.
All right, let me get my placement information updated. When was he moved? What day was he placed in Arkansas?
He was placed December 1st. Actually, no, December 2nd. I apologize. Yes.
Do you know what county it's in, or it's out of state? Let me just pick out of state. What's his level of care right now?
His level of care is intense.
Okay. And any particular reason for the placement change according to below?
Yes, Your Honor. Gavin experienced a lot of behavioral problems from running away in his placement in Baytown. He was in and out of placement at all hours of the day and the night, and we were not able to secure a placement here in Texas. And so he is at Little Creek at the moment.
Okay. I think, I don't know if the other parts of the report are up to date, so I'm just going to ask you the questions directly.
Yes.
Is he up to date on his medical, dental, and vision checkups?
He is actually up to date for now on his medical. His dental is needed. Little Creek is actually working with their nurse to get his dental scheduled and all figured out for the next. I think they're planning to get it done within the next few weeks.
Okay. Is the permanency goal still unrelated adoption?
So we've had a few changes, Your Honor. While back in November, Gavin reconnected with his mom, Ms. Brittany McCool. I have been exploring that option with Gavin, as is the only option that he is willing to explore at the moment. I continued the search for another family just as a backup. But right now we are currently working with mom to try to finalize that placement. Mom has been doing significantly better. She did receive treatment for alcohol abuse, and he has been in therapy. He has been engaged in her recovery, and she's actually doing very well. Our goal is to get a family therapy started, but first, we're working with Gavin for him to participate in therapy individually so that he can start working with mom as well.
Okay, thank you. Miss Savage or Miss Harding, if you could help jog my memory. A lot of this is new news, correct?
Yes, Your Honor. From
Okay.
our last term hearing, Mom wasn't necessarily in the picture. Gavin was still in Houston.
Okay.
So
I'm just making sure I'm not missing something, because a lot of this is like very different from where we were
Yes.
back in December. I mean, our last hearing was October, but didn't we have a meeting in December?
Yes, that was when Mr. Gavin kept running away from placement.
Right. So all of this is new to me. Okay. I wanted to make sure I wasn't forgetting something, but yeah, I wasn't, I was a little caught off guard by some of this. Okay. So does he still have issues with high cholesterol? Is that still a problem?
It is not a problem as of right now. He he has gained some weight. So Gavin, and I will let Gavin explain more of how he has felt the last couple of months. But Your Honor, you might be aware Gavin struggles with placements after around the 3-month mark. Typically he will, after 3 months, he does very well for 3 months, and after 3 months, he struggles with behaviors, he runs away, he engages in substance abuse, and so on. Being at Little Creek has really forced Gavin to engage in or at least somewhat participate in therapy and really work through his trauma. And we have seen that he did struggle with depression in the last few weeks. I got reports that he's doing a little bit better. I do plan to go up there and visit with him on Monday and just do a follow-up to see overall how he's doing. But to go back, he did gain some weight, but he's doing good.
Okay. Wisdom teeth. Did we get that done yet?
We have not. He had 2 appointments, one in October and one in November. The one in October, he refused to do it because he was playing football.
Right.
The one in November, that is when he started to run away from placement and did not stay put in long enough for us to be able to take him to the appointment. I am working with Little Creek to get a new evaluation from the dentist there so that they can do the determination. Every time, every dentist seems to have a different opinion in my experience.
Okay. How are we doing on therapy?
Again, I will let him talk a little bit more about it. He participates. He does what he's told to do. But at this point, he is definitely being pushed to open up and address his trauma, which is very new to him. Typically, the therapists that he's had before, they kind of give in to Gavin and allow him to not participate or really truly engage. And he has finally reached a therapist that is pushing him to really open up and work through his trauma. A big part of Ms. McCool's recovery plan is for her to continue therapy. She really wants to address the trauma that they went through in the past. And so she is really pushing Gavin as well to participate in therapy so they can both heal.
Okay. I pulled up the CASA report, which has some more of this information. Looks like he's on several psychotropics.
Yes, he has continued to be on the same ones that he was throughout his stay in Houston. They have monitored him, and I have discussed with Little Creek that my intention is for him to step away from medications as much as possible. They have been working with him to stabilize him in the last 3 months. Again, he's had some ups and downs, so they are evaluating that on a weekly basis.
Okay, thank you. And according to the CASA report, it looks like his last review was this month, so that's up to date.
Yes.
All right. Has everybody received the results of the psychological evaluation?
No, not yet. Oh, I apologize.
The
Which
old
one?
one. I just want to make sure everybody has it. It's the old one.
I have the
Yeah.
one from June. I don't think he's had an updated one.
Okay. I just want to make sure everybody's working off the same information. All right. And you believe that this contact that he's having with Ms. McCool at this time is in his best interest?
I do, Judge. Gavin has been more cooperative. He is seeing it as a goal and definitely working. He understands where Ms. McCool stands. At this point, Ms. McCool is working towards becoming stable and getting her own residence. And she has been very clear and honest with Gavin, and I think they're both on the same page. Again, it's really pushing him to work towards that goal and stay focused.
Okay. All right, Mr. McCaskill, let me ask you this question. Do you believe that this placement that he's in Arkansas is the least restrictive placement that's available? Ms. Nevadas?
Yes.
All right. Do you believe all of his educational needs are being met?
Yes.
All right, Mr. McCaskill, do you have any questions for Ms. Nevadas?
No questions, Your Honor.
Ms. Savage,
No questions, Your Honor.
what are your thoughts on things, Ms. Savage?
Gavin's doing pretty good right now. I like that he's in a place where he has to stay put, even though I know he's not fond of that. He did just level up. It took him a while, but he's making progress. I agree with Miss Nevadas. I think Miss McCool being back in his life in some way, shape, or form has been really good for him. I know mom's working hard to get back in a good place, and Gavin understands that. And so they're both just working through what they need to work through. So hopefully that can be our continued goal. But yeah, I think right now everything is going pretty well.
Okay. Ms. Harding, I've looked at Ms. Winnike's report. I think we've addressed most of what was in there.
Yes, the only thing I'd like to add, Your Honor, is that, we understand that Gavin has been struggling and that some of his weight gain has been related to his, transitions and those things. We do not have any information about the last time any blood work was completed from his psychiatrist. And so we would request that if the psychiatrist has not done any labs to check his Docket levels, his valproic acid levels, and check his cholesterol and his A1C to see if he's, got any additional medical issues that this weight gain is causing. We'd like to either cut them off at the pass if possible or have them addressed. And so that would be our concern for him, that because he hasn't had a routine medical exam since August was his annual, we'd just like to have placement take him for the doctor to consider running some labs and checking those things out.
Okay, thank you. Gavin, is there anything else that you want to add this morning?
No, sir.
Do you have any questions for me?
No, sir.
Okay. Well, I'm glad to hear that you're doing better, and I'm glad to hear that you're having contact with your mom. It looks like you have a visit coming up this week.
I will be there, Judge, to visit with him.
Okay. All right. Then based on what I've heard this morning, what would you say your permanency goal is at this time? I don't think we ever established Belong's goal. I know it was adoption, but now we're talking to mom. So have y'all set aside a new goal?
As officially, it would still be adoption. Like I said, I have not completely closed that door.
Okay.
Mom is still working towards becoming stable, continuing her sobriety and so on. So I would like for her to make more progress before we close completely the door towards adoption.
Okay. I think that's appropriate. Okay, then for the purposes of the permanency review after final order, the court finds that the permanency goal of unrelated adoption at this point in time is still in Gavin's best interest. Court finds that the contact that he's having with Ms. McCool at this time is in his best interest. And I'm going to authorize that to continue happening and at the frequency and duration that the parties feel is appropriate. Going to find that he's up to date on his medical and vision, but I'm going to order the labs and the blood work. Let's get that done as soon as possible and make sure that everybody gets a copy of the results. I'm also going to encourage you, Gavin, to make sure that you stay available so that you can get your dental done. Dental health is very important, especially at your age. And those wisdom teeth, that's important too. These are things that might kind of seem like scary or annoying, but your dental health has an effect on your entire body. And at a young age, it's very important to understand that the better care you take care of your teeth, the better your entire body is going to work out. I mean, your dental health can affect your cardiovascular health. So please listen to the doctors, please listen to everybody and follow up on that stuff, because we all want you to have a long, healthy life here. Court finds that he is participating in therapy and that he is receiving several psychotropic medications and that the reviews of those medications are up to date. Court finds that he is in the least restricted placement available at this time. Gavin has had the opportunity to express his desires as to his placement. And since our last hearing, the mother, Ms. McCool, has gotten involved and come forward. And again, we've already discussed that contact. I know last time we had a discussion about the contact numbers at his placement. Now he's at a new placement. So I do want to make sure that he's got all up-to-date contact numbers and lists so that he can get in touch with people if they call or he needs to call. I'll find that Belong has made reasonable efforts toward achieving a permanency goal by reviewing it and also working with, with Ms. McCool and having Gavin available for adoption efforts, even though we might not be going that route anymore. Our next hearing is going to be on September the 4th, 2024 at 9 a.m. Anything I failed to address? No? Okay. Well, Gavin, as always, if you need to talk to me or you want to talk to me, you know how to get a hold of Miss Savage or Miss Winnicky or Miss Nevades. Just let them know and we'll get an appointment set up. Okay?
Yes, sir.
All right. Good luck to you. And for everybody else, thank you for your time and your service. I appreciate you.
Any
All
objection?
parties are excused.
No objection.
Thank you.
No objection.
All right. Well, with that, Mr. McCaskill, would you please begin the announcements?
Thank you, Judge. Drake McCaskill, attorney for the department. Mr. Minen.
Lane Minen, permanency specialist with Belong.
Again, permanency supervisor with Belong.
Anna Swallow, attorney ad litem for the respondent mother, standing in for Jennifer Harris. Ready?
Maureen Yanis for Father Brandon Sharp. Judge, he is not present, but I can announce ready since we reached an agreement.
Deborah Fuller, attorney for the children, ready, Your Honor.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the children.
Reva Johnson, Casa ad litem. Sorry, I forgot to unmute.
I think that's everybody.
Judge, I don't know if my client stated her name.
Ms. Shimote,
Juliana Shimote.
we are here today for a final trial. I understand the parties have an agreement. Mr. McCaskill, would you like to state the terms and conditions of the same?
Yes, Judge. Like I stated earlier, we did attend mediation on the 13th, and we were able to reach an agreement for a final order with regard to auto. The agreement itself doesn't necessarily lay out all of the terms and conditions, but I'll go through the proposed order that was also attached to that Rule 11 agreement. So first and foremost, the parties agreed that the Rule 11 agreement was in the best interest of the child. The department was renamed or referred to as DFPS throughout the agreement. Then third, the parties agreed to the terms of the proposed final order in suit affecting the parent-child relationship included in the Rule 11 agreement under Attachment A, and the parties further agreed to present this order to the court today for signature. The parties agree, this is number 4, the parties agree that the department will provide Ms. Shimote on or before today's date the children's original birth certificates and social security cards, and then agreed to use electronic signatures as if it were a handwritten signature. As far as the actual order is concerned, I'll hit the high points, Judge. First, there's a loving and caring order in the Children's Bill of Rights that is included in the final order. As far as conservatorship of the child, Ms. Shimote will be named as sole managing conservator of the child. Mr. Sharp will be named as possessory conservator of the child, and each have the specified rights and duties under the Texas Family Code regarding their specific appointments. Mr. Sharp will pay child support. Let me get to that, which is the, let me give you the specific amount. Sorry, it's not laid out like a typical order. It follows one of the formats of our orders, and so I've got to look at the various attachments. He will be paying $198.07 per month, with the first payment beginning April 1st, and like payments thereafter until the standard guidelines for the termination of a child support obligation in the Texas Family Code. Mr. Sharp will also have possession and access of auto for, I believe it's 1 weekend per month, beginning at 6 p.m. On the day that school recesses and ending at 6 p.m. on the day before school resumes. And then it's a standard possession order with regard to the holidays and other times of possession access throughout the year. I believe, Judge, that's the high points. That's all the major aspects of it.
Okay. Now you covered conservatorship, child support. I'm assuming, is there medical support or no?
Yeah, it's just there's medical support. Let me get to that attachment as well. I'm sorry. I believe it's the $25 a month. Yeah.
Okay.
So let me just verify that. It is the minimum of $25 per month, and then the standard language regarding health insurance and medical expenses for the child.
Is it 50-50?
Yes, sir.
Okay. Miss Swallow, I don't know if Miss Harris gave you any notes. Does this appear to be the agreement that she and her client entered into?
Yes, Judge.
All right. Miss Giannis?
Yes, Judge.
Miss Fuller?
Yes, Your Honor.
Casa?
Yes, Your Honor.
Okay. Ms. Shimote, you heard the terms and conditions of the agreement, or at least the high points, as Mr. McKeska said. Is that the agreement that you entered into?
Yes, sir.
Did you have the opportunity to discuss it with your attorney?
Yes, sir.
And you understand what's expected of you out of the agreement?
Yes.
All right. And you're asking the court to sign this order today as far as your agreement is concerned?
Absolutely.
Okay. All right, then. Anything else anybody wants to present before I hear from the ad litem's?
No, Judge.
No? Okay. Ms. Fuller?
I just want to say that Ms. Shimote worked very hard during this case. I mean, she was on top of it from the very beginning. She was able to get her children back sooner than most parents do in the cases because she was so involved with her services. She's maintained her sobriety. Her kids are very happy. They've been home with her for a while, and they're very well taken care of by her, and she should be very proud of herself. Not everybody can survive a CPS case, and she did it in a fantastic way for her children, and they really wanted to be home with her, and she was able to get them home fairly quickly because of all the hard work that she put in.
Thank you, Ms. Fuller. Ms. Johnson?
Yeah, I think Deborah said it really well. I feel very comfortable with Joanna being the managing conservator, and I think the kids are in a good place right now.
That's wonderful. Then the court will find that the agreement of the parties is in the best interest of child, and the court will adopt and approve the agreement and make it an order of the court as stated here on the record today. Name Ms. Shimote as the permanent managing conservator and Mr. Sharp as the possessory conservator, and order Mr. Sharp to pay $198.07 in child support beginning April the 1st, 2024, with a like payment due on the 1st of the month, every month thereafter, as well as medical support beginning April 1st, 2024, in the amount of $25. Parties are to split any unreimbursed medical insurance cost 50-50 out of pocket. Mr. Sharp is to have possession and access of the child auto for 1 weekend per month, Friday 6 to Sunday 6, or when school recesses to 6, and a standard possession order for the holidays. There's a loving and caring order and a children's bill of rights as well. I think we've covered everything that's important here today as far as our hearing is concerned. And obviously we need to get the birth certificates and social security cards to Ms. Shimote, and the order to me, and I'll sign it. And anything else I failed to address, Mr. McKeska, on the order?
No, sir.
Okay. Well, thank you all for your time and your service. I'm really glad to see the case come to an end like this, and I want to give Ms. Shimote a round of applause. You did a great job. You've worked really hard. This is what we want to see in these cases. I wish they would all end like this. Really do. So I echo what Ms. Fuller and Ms. Johnson had to say. Anybody else want to say anything to Ms. Shimote before we close? No? Okay. Well, I guess Ms. Fuller said it all. Good luck to you, ma'am. Anything else, Mr. McKeska?
No, sir.
All right. All parties are excused. Thank you for your time and your service.
Thank you.
Thank you, Judge.
Acosta, your client. Oh, it looks like
Yes.
she might have gotten it figured out. Okay, there she is.
I barely got it to work. I was having issues with the volume.
Okay, you can start your video now, ma'am. And if I could get you to set your device down so it's still, because it's really distracting when it's shaking around.
You good.
Thank you.
You're welcome.
In the 38th Judicial District Court of Uvalde County, Texas. Court is streaming via YouTube and Zoom and the Kendall County Courthouse. Is there any objection?
No objection.
No objection.
No objection.
With that, Mr. McKeska, would you please begin the announcements?
Thank you, Judge. Drake McKeska, attorney for the department. Ms. St. James.
Avon St. James, the child protective investigator.
Irene Agosta, attorney ad litem, appointed to represent Mary Jane Sandoval, the mother. Ms. Sandoval, can you state your name, please?
Mary Jane Sandoval.
Anna Swallow, attorney ad litem for the respondent for the child. The child is present on the screen, Judge.
She's asleep.
Let's see you. Or
I don't want to wake up.
this is a her.
Yeah.
She's
Crystalline?
beautiful.
Yeah. She's premature. She only lasted in the NICU for 1 week, and they released her at 35 weeks home.
Good.
And
Nice.
there was no issues, no nothing. If you want any paperwork, I can call San Antonio and get it for y'all.
All right. Well, let me explain to you how this works just so you understand. We have to go through the court proceeding and we have certain procedures that we follow. And your attorney will help get any of that information to the other parties after we do this today. Okay.
Okay.
All right. Thank you. All right. While the parties talk to me, I'm going to put you back on mute. Okay, Ms. Sandoval? All right. Mr. McKeska, did you all reach an agreement?
Yes, Judge, we were able to.
All right. What were the terms and conditions of your agreement?
Yes, Judge. Ms. Sandoval has agreed to participate in the services that were requested, which include parenting, counseling, a domestic violence program, and then submit to drug testing, and then if positive on one of those screens, conduct a drug and alcohol assessment. Obviously, that would also include following the recommendations from any of the service providers. The parties also agreed that the department will seek out and mom can address multiple services with any single provider, provided the provider does have a set curriculum. So, for example, if she can address domestic violence with her individual counselor, but just making sure that that individual counselor has a set domestic violence curriculum or program that is incorporated and not just lumping it into a general counseling session. And that's it.
Ms. Swallow, is it the agreement as you understand it?
Yes, Judge, it is.
Ms. Acosta?
Yes, Your Honor, it is.
All right, Ms. Sandoval, you can unmute now, and I'll ask you a few questions. All right, ma'am, did you hear the agreement that Mr. McKeska stated?
Yes.
Is that the agreement that you made?
I'm trying to get the thing back on the camera.
I hear you. Is that the agreement that you made?
Yes.
And did you discuss it with Ms. Acosta, your attorney?
Yes, I told her I'm willing to do the drug test and the counseling and the parenting.
Okay. And you entered into this agreement voluntarily?
Yeah.
And nobody forced you to agree to it?
No, no one forced me to.
All right. Ms. St. James, do you believe that this agreement is in the best interest of Crystalline?
Yes, Your Honor.
Okay. And you believe that these services are necessary to alleviate the effects of abuse or neglect that has occurred, reduce the continuing danger to the physical health or safety of the child caused by an act or failure to act of the parent, and to reduce the substantial risk of abuse or neglect caused by an act or failure to act of the parent. And you believe it's in the best interest to permit the child and not any siblings, but the child to receive any services as well if they're recommended.
She's still little to do any.
hang on just a minute, Miss Sandoval. I understand, but we do have some services that are available for infants when it's appropriate. Is your answer to that yes, Miss St. James?
Yes, Your Honor.
Okay. Then, based on the evidence before the court and the agreement of the parties, the court will find that the child has been a victim of abuse or neglect, or is that substantial risk of abuse or neglect, and there is a continuing danger to the physical health or safety of the child caused by an act or failure to act of the parent. Court will order the required participation in the form of the services that you all agreed on. Ms. Sandoval will do parenting classes, attend counseling, address domestic violence issues, drug test, and if she's positive, she will do a drug and alcohol assessment, and then she will follow all recommendations from those services. And it's agreed, and the court orders that if mom finds multiple services at a provider, as long as they check out with the parties, that is appropriate. Our compliance hearing is going to be June the 18th, 2024 at 11 a.m. June 18th, 2024 at 11 a.m. Ms. Sandoval, I want to make sure you understand that this is a very one of the least restrictive ways we have to help you and your child so that the department doesn't have to get more involved in your life, okay? If you don't do these services that I've ordered, then you run the risk of us having to go through more stringent legal proceedings, and you run the risk of the department getting more aggressive as far as the legal conservatorship of your child, which could result in a removal. I don't want to see that happen. I don't think anybody here wants to see that happen. We want to see you get the services you need. We want to make sure Crystalline is safe, and we want to get out of your life. But you have to do these things. Does that make sense? You can nod your head. Okay. Court will note that she did nod her head. All right. If you have any other questions, get with Mr. Costa after the hearing, and she'll help you. If you have any other information you want to provide the parties, you get it to her as well. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay. All right. Well, thank you all so much for your time and your service. And if nothing further, all parties are excused.
Thank you.
Thank you.
Thank you.
You have a mother. We don't have a father.
Judge, the father is incarcerated with TDCJ in the Dominguez unit, and so I don't know if he's going to be available for today.
Okay. Mr. Cabrera, did you have a chance to talk to him?
I have not yet had a chance to confer with him, Your Honor, but I do intend to once I'm able to reach him.
Okay. So do you have an agreement with the mother today, Mr. McKeska?
We do, Judge, and just so everybody is aware, and it's clear on the record that Mr. Ruckin is in a criminal trial, and he and I were communicating with each other via text message through the lunch hour. And so through those communications, we were able to solidify the terms of the agreement.
Mr. Saldivar is here for Ms. Pearsall.
Yes, Your Honor.
And she has been able to communicate her agreement to you?
Yes, Judge, she's in agreement. She saw the children there at Boysville, and they're doing well.
Okay. Okay. Then with that, Mr. McKeska, would you please begin the announcements?
Yes, Judge. Drake McKeska, attorney for the department. Ms. Gonzalez.
Taylor Gonzalez, family-based caseworker.
Carol McCata, family-based supervisor.
Margaret Burr, I'm attorney for the father.
Richard Saldivar, covering for Alana Pearsall for the children. Ready?
Ms. Davis, could you announce, please?
Anna Davis, I'm
Ms.
the
Davis,
mother.
I'm going to mute you just because I'm hearing some background noise, but in a minute, I'm going to ask you some questions. So you'll need to unmute when I ask you, okay? Thank you. All right, Mr. McKeska, what are the terms and conditions of the parties' agreement?
Yes, Judge. With regard to Ms. Davis, Mr. Ruckin and I were able to agree that the department be named as the temporary managing conservator. Ms. Davis would be named as the temporary possessory conservator. That will hold a family group conference to develop a family plan of service nearly tailored to address the reasons for removal in this case. We're asking the court to waive child support and medical support at this time. The department has agreed to submit for a home study on the maternal aunt, Alyssa Davis. And the department would submit for that home study in San Antonio. She recently moved.
You
And then
froze up. You froze up. I heard you say the department would submit for that home study, and then it looked like you were taking a really long pause.
apologize. The department would submit for the home study upon the receipt of Alyssa Davis's address and all of the personal information, identifiable information for her roommates to be able to run their necessary background checks. I will note also, Judge, that the department has already submitted for a home study on paternal aunt and uncle in Kerrville, and the aunt's name is Paige Gomez. And it's my understanding that Miss Anna Davis is set to enter into an inpatient treatment program, and so visitation would be based off of what is allowable through that program.
Is that the entire agreement?
Yes, Judge.
Mr. Cabrera, is that your understanding of the agreement, even though you haven't talked to your client about it yet?
Your Honor, my client is Mr. Adam Sanchez. I'm not able to agree on any terms. I believe this agreement is for the mother.
Right. I just wanted to make sure that you were privy to that conversation and you understand what the other parties are agreeing to. You don't have any ability to agree to it because you haven't talked to your client yet.
Correct, sir. That is my understanding of the agreement.
Okay. I just want to make sure I get it on the record that he's not party to this. Okay. And then Mr. Saldivar, did you get approval from Ms. Pearsall? Okay.
Yes, Your Honor.
Okay. So Ms. Davis, you can unmute now.
Okay.
Okay. You heard the terms and conditions of the agreement?
Yes, I did.
Is that the agreement that you made?
Yes, that's what I talked about.
All right. Did you have the opportunity to discuss it with Mr. Rudkin?
Yes.
And do you understand what's expected of you?
Yes.
Are you entering into this agreement voluntarily?
Yes.
Were you forced in any way to agree to it or made any promises to get you to agree to it?
No.
Are you asking the court to approve the agreement today?
Yes.
All right. Thank you. Ms. Houston,
Yes.
you believe this agreement's in the best interest of the child?
Yes, I do.
And is that the agreement as you understood it?
Yes, it is.
Okay. Thank you. All right. And then I've got waivers of service on both Ms. Davis and Mr. Sanchez, correct?
Yes, Judge.
All right. Ms. Davis, do you currently, well, you're about to go into inpatient rehab, correct?
Sorry. Yes. I will. I'll get the date tomorrow when I go see my probation officer.
Okay. Before you go, I just need to ask you a few questions. Do you have any funds that you could use to hire an attorney in this case?
Not right now.
Did you have anything that you could sell or anything that you could liquidate that would allow you the funds to pay for an attorney?
No.
Do you have anything in savings?
No.
Are you asking the court to find that you're indigent for purposes of this case?
Yes.
All right. For the purposes of this case, I will find that Ms. Davis is indigent and entitled to continued representation by Mr. Rudkin. And I will find also that Mr. Sanchez is incarcerated and thus unable to afford an attorney, and the court will find him indigent and keep Mr. Cabrera in his appointment as Mr. Sanchez's attorney. Court finds that well, let me ask another question. Ms. Gonzalez, is everything in the affidavit you filed as of today still true and correct?
Yes, Judge.
And to the best of your knowledge, did the department make all reasonable efforts to avoid a removal in this case?
Yes, sir.
Did the attorney stipulate to the reasonable efforts made by the department?
Yes, Your Honor.
All right. And Ms. Gonzalez, do you believe that the agreement is in the best interest of the children?
Yes, sir.
You believe it's in the best interest of the children to be in the temporary managing conservatorship of the department?
Yes, sir.
All right. Based on the agreement of the parties and the testimony, the court will find there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child, which was caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of continuing danger if the child is returned home. Court will adopt and approve the agreement of the parties, name the Department of Family and Protective Services / belong as the temporary managing conservator, name Miss Davis as the temporary possessory conservator. The court makes no orders as to Mr. Sanchez today. Court will find that the court orders the parties to participate in a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the children, Monty and Minnie, into care. And the court will order the child support and medical support be waived at this time. Court orders a continuation of the effort to do a home study on the paternal aunt and uncle, the aunt being Paige Gomez, and then also to submit for a home study on the maternal aunt, Alyssa Davis. Only upon the receipt of Alyssa Davis's address and all of the personal identifiers and information needed to run background checks on any roommates. Court will order that visitation occur per agreement of the parties pursuant to whatever parameters the inpatient rehab facility sets for visitation. I do want to make sure if there's an issue, I need you to let me know that if there's the ability for the mother to get visitation while she's in rehab, that we make sure that gets done as soon as possible. We'll have our status hearing April the 25th, 2024 at 11 a.m. April 25th, 2024 at 11 a.m. I have to admonish you, Ms. Adams, that the state of Texas, or excuse me, Ms. Davis, the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction, as they are now, or termination. I want to make sure you understand, Ms. Davis, that year started on March the 7th, 2024. Okay, so we're 13 days into it. Your dismissal date in this case is March the 10th, 2025. You don't have to take that long. It can go faster than that, but that's as long as it's going to go. So if you have any problems obeying the orders or following the orders, then you're setting yourself up to potentially have your rights restricted or terminated. So I want you to understand now is the time to start. Going to inpatient is a huge deal. I applaud you for that. It's a big step in this process, and I'm looking forward to coming back on our status hearing date of April the 25th and seeing how you're doing with your treatment. Okay.
Thank you.
You're welcome. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay. Well, thank you all for your time and your service. Good luck to you, Ms. Davis. And if nothing further, I'll see you all April 25th, 2024 at 11 a.m. All parties are excused, and that concludes our docket for today. Have a good evening.
Thank you.
Thank you.